Welcome, everyone, to our November Family Law Community of Practice. I also believe you can unmute yourself to speak, so you don't always have to raise your hand and be called on. You can come in, jump in with a question, either in the chat or by unmuting yourself to speak. I'm very excited today that we're going to talk about leveraging immigration affidavits of support in divorce cases. How come my screens are not changing? Okay, there we go. And the opinions you're going to hear today are Veronica Thronson's and mine, and do not necessarily reflect the views of the Department of Justice or the Office on Violence Against Women. Is it going? Is yours changing, Veronica? The slide, maybe it's just a delay. The slides that we're providing you today are intended to guide and to lead our discussion and as a reference for you following the training in addition. So there'll be more detail on the slides than we might cover today, but they'll be available for you as a member of the community of practice.
Okay, thank you. Thank you, Anna. And good afternoon, everyone. My name is Veronica Stronson, and I'm a clinical professor with Michigan State University College of Law. So today we are going to cover affidavits of support. Many of you may be familiar with the affidavits of support. We have provided you with training on this topic before, but now more than ever, we want to make sure that you have updated information, particularly in how to use the affidavits of support to help your immigrant clients who are survivors of domestic violence. So, as you know, there are so many obstacles for people to eventually be able to leave an abusive relationship. And one of them is economic barriers that they may have. They may not have a job. They may not be able to provide for themselves to be able to leave that relationship. So studies in NewUp and Leslie in particular have done a lot of research in trying to figure out what are the barriers for people to leave an abusive relationship. And the studies that NewUp has conducted have come up with things that are not really surprising for us who deal with immigrant victims, with loss of income being one of the barriers for leaving the abusive relationship. In many instances, the clients, the immigrant victims, may be undocumented. They may not have an avenue, or they may not be able to speak to someone who can counsel them and determine if they would qualify for immigration relief. So it is important that you, as advocates and attorneys, know this information in order to guide your clients through the process of how to obtain financial independence and move away from the abuser. So in many instances, when couples are married to each other, and they are going through a divorce, and every state is different, there are different factors in which the family court judge is going to consider whether this person qualifies to get spousal support or alimony. In most states, the length of the marriage is one of the factors that the judge is going to consider. And in many of our cases, immigrants haven't really been married to their abuser for that long. And so it's very hard for them to be able to qualify for a judge to order alimony for them. So the factors that they have: contribution of the parties to a marital estate. If the person doesn't have lawful immigration status, maybe the victim is not working, so she may not be able to contribute to the community, to the marriage. What is the life status of the parties? What are the earning abilities? All of those are going to be common factors that the judge is going to consider in determining whether this person qualifies for alimony. And so what's important is that the judge also has to look at equity, right? And so to determine how is this person going to survive if the parties separate and divorce. And so when the affidavit of support is in place, that is something that many people don't know that they can use as trying to get the abuser to provide for them because of this affidavit of support that was filed in their cases, their immigration case. So the enforcement of the affidavit of support is going to be very important. And one of the things that I'm going to tell you is that most family court judges who are adjudicating the divorce cases have no idea what you're talking about, right? And so one of the things that is going to be very important is that your job is going to be to educate the judge, to explain to the judge, this client came because the abuser filed papers for her and he signed this legally binding document that I'm trying for you to enforce. And this is completely separate over whether your client is going to qualify for alimony. So if you remember the factors, and you should be familiar with the alimony factors in the state in which you practice, then you need to be able to say, okay, my client may not qualify for alimony as part of the divorce, but I can ask the family court judge to enforce the affidavit of support because it is a contract. And let me tell you, there is a lot of case law where the judges have not refused to enforce the affidavit of support. A little bit of education, and I know NewApp is working on a document, and Leslie, I don't know if you want to talk about that
Sure.
now to just keep people up to date.
Sure. So we've been collecting, both Veronica and our students at New App have been collecting affidavit of support cases for a number of years. And one of the things that I find most frustrating in these cases is a lot of times in the immigration world, generally around divorce issues, the lawyers that do those affidavit of support cases don't understand domestic violence. And there are often domestic violence cases that are these affidavit of support enforcement. And so they're very powerful, helpful to immigrant victims in particular. And so we are working, there was a case in Texas, one of my former interns who's now a family lawyer had, that was going potentially to the Supreme Court in Texas, in which he won a very good decision out of the Court of Appeals on affidavits of support and victims. And so we got the law firm of Wilmer Hale that is working with me and Veronica and Carlos to create a model brief, essentially, that you all can use to educate judges about affidavits of support. And we're expecting to see that be completed, hopefully in the next few months, which is a version of the legal research on affidavit of supports that really looks at how to work with these and use these in cases that also where there's co-occurring, where there's domestic violence. And then I'll stop there because I want to give more of the time to Veronica. Is that what you wanted me to cover, Veronica?
No, that's fine. Thank you. So just for some of you who may not be familiar as to how the immigration system works, we're going to give you like a minute crash course on this so you understand how is it that the affidavit of support is coming into play. And one is that most people who immigrate to the United States have come to the United States because of a family petition. Right? So we are talking about families. We are talking about a husband petitioning for a spouse, a husband petitioning for children, petitioning for a parent. And so this is the universe of people who may have gotten an affidavit of support filed on their behalf because without that affidavit of support, that immigrant is not able to obtain that green card. So it is important for you to ask, right, as you are doing your intake and you are trying to get all the information from your client, one of the first things should be, how did you come here, right? Like they come, they show you a green card. How did you get this green card? That is important because then you are going to determine if the client who is sitting with you has an affidavit of support that could be enforced after. So the sponsor, and let's, for sake of argument, say the husband petition for the wife, right? So the husband has to file this affidavit of support for the immigrant spouse to get lawful permanent residence. So, you just, think back to when you took contracts in law school, right? Like you have, what is the consideration? What is it that you are getting by signing this contract? And what you're getting for your spouse is the ability for your spouse to come to the United States and to get that lawful permanent residence, right? So it's only going to be enforceable if your client already got that green card. Okay, so that's the end of the bargain, right? Like I filed this affidavit of support, I filed for my spouse. Now you, government, are giving her the green card. And then but that's what the government gave you, right? Like your spouse got the green card. Next, please. So prior to the law changing in 96, affidavits of support were in place, but they were not legally binding. You may be familiar with all cases in which people filed the affidavit of support, but nobody was trying to enforce them. Now they are legally binding because what the government wants is to make sure that the intending immigrant is not going to become a public charge and rely on public assistance, right? Like the government wants people to come to the United States and be self-sufficient. And if for any reason they are not self-sufficient, then they need someone else to be responsible for them. And that's how the affidavit of support comes into play, right? Like, government, I promise I'm going to support my intending immigrant spouse, parent, or child at 125% of the poverty guidelines, and she is not going to rely on public assistance because I am committing to supporting her, right? That's basically what the affidavit of support does. It is completely separate, as I said before, from child support or from spousal support. Not everybody is going to have an affidavit of support. For example, if you have someone who may qualify to apply for a U visa, for example, right? Maybe the spouse doesn't have lawful status, so he didn't file an affidavit of support for that person, right? Maybe a child, right? Special immigrant juvenile, that child is not going to need an affidavit of support. People who file under the Violence Against Women Act, when they file a self-petition because the spouse never filed for them, they are not going to have that affidavit of support, right? It's not required. So this is the category of people who are not required to have an affidavit of support. So you are not going to see that in their cases as you are asking them if they have that paperwork. And so the forms, and we have the language here from the actual form, because you have to make sure that you explain this to the client, right? In many instances, the client said, I have no idea. My husband just signed a lot of forms. I don't know what he committed to, right? And that's normal. I mean, it's very overwhelming, even for attorneys, when you look at the whole list of documents that people have to file in order to eventually get that green card. And so, but it is important for you as practitioners to know that the sponsor is committing to supporting the intending immigrant, and that they are also agreeing that the government or the immigrant spouse can sue them and can bring them to court. They are agreeing to submit themselves to the personal jurisdiction of the court, and it can be state court or it can be federal. And so that's important. That's why if it's state, right, for example, in a divorce action, you can get it enforced. And if you are going to bring a breach of contract in federal court, you can also do that. But the sponsor is not going to be able to say, no, I did not agree to this, but because he did, right? Like most people lawyers included, don't read the fine print. And this is actually not even fine print. This is actually like on your face print that says you are promising to do all of this, right? Like you are entering into a contract and this is what you are committing to doing. Okay, so these are a couple of examples of where you are able to see this type of affidavit of support and attorneys asking to enforce it, right? In a divorce, which is the most common. A legal separation is interesting because in a legal separation, you are able to still ask to enforce the affidavit, but there is something that I'll cover in a couple of minutes. In custody, for example, in child support and spousal support, you are able to ask for that. And then civil contract in federal court, in small claims, we have seen it, right? Like sometimes if the state has given the immigrant benefits, they may actually come and sue the sponsor. The state cases are not as common, but there have been a couple of cases in which a sponsor has sponsored an elderly parent, for example, and then that parent is relying on benefits for like nursing homes and things like that. And then the state is trying to come and recoup all those expenses that they incurred on behalf of the elderly parent. And they have gone after the sponsors to pay them back for the benefits that they gave this elderly parent, for example. Yeah, it's not as common. There were a couple of states that said we are not going to enforce, and it's actually very hard for people to get public benefits, particularly immigrants, because they are barred from qualifying for public benefits for the first 5 years after they obtain a green card. And after those 5 years, they are going to be subject to deeming provisions, meaning they take the sponsor's income as part, they deem it available to the immigrant, so that the immigrant basically is going to be very hard to get those benefits. But after 5 years with a green card, that person, or if they are still married to a US citizen, they can apply to become US citizens after 3 years, or 5 if they are no longer married to that person, and then they may qualify for benefits based on their income and not so much based on the immigration status.
Right. And the other thing that's important to understand, and this is a whole other training, but just so you know, for immigrant victims that have gotten protection orders or where there's been finding of domestic violence, or just for the first year, victims they don't have to, the deeming issues don't apply to victims. So you may see more cases where victims have more access to state funded benefits than immigrants do generally. So when there's domestic violence in a relationship, there's a deeming exception, so there's more access to benefits. So you should just be aware of that. And I can share some information on that. And I'm also going to share our public benefits map so you can look at what kinds of benefits people may qualify when in your state.
And also important, and I assume we are going to be doing a training on this, right? Like with the big, beautiful bill that was signed in early July, there are several changes to public benefits eligibility that are going to take effect. Some of them took effect now, some of them are going to start taking effect early next year. So you need to be aware of that as well.
We definitely are in the process of updating all of our benefits charts.
Yes, and we are creating the Michigan version of those benefits as well. So what excuses could you have to say, I do not want, I don't think I should be subject to having to support my spouse? One of the most common is she tricked me into marrying her, for example, right? Like she married me for immigration purposes. She didn't really want to have a life with me. So I have the defense of fraud, right? And on the regular contract language, right? In many instances, people are able to void a contract because they may allege fraud, but contract defenses don't apply to the affidavit of support. So even if you say fraud, that is not a defense for the enforceability of the affidavit of support. And we have here a couple of cases that address those issues specifically. We also have in the materials an article that I wrote a couple of years ago that analyzed a lot of the laws and all the defenses that people have used, right? Any defense in the book, believe me, abusers have tried to use to avoid having to support their spouse, and the courts have said the contract defenses don't apply.
Can I just jump in here too? Just one note is if you're ever working on a case where it should be a divorce and it's against a foreign-born victim that isn't a naturalized citizen, and they're claiming that they're asking for annulment and not divorce, please call us for technical assistance, because although it may not affect the affidavit of support, we've seen cases where abusers will turn that into, they'll try to get the U.S. attorney to issue marriage fraud, like start a criminal case for marriage fraud against the victim. So just be aware that's not a benign issue. And if you run into it, you should call us.
Another thing that is very important too is that the immigrant, the person who is trying to enforce that affidavit of support, has no duty to mitigate. So I usually tell my clients, you can be a bum if you want to, right? Like you have no duty to go get a job for the sponsor not to have to support you under the affidavit of support. So there is no duty to mitigate because you are not required to find a job and contribute to the household. So that's important too. So, the clients always laugh when I said you can be a bum, right? And let me tell you, most immigrants want to work, right? They want to be self sufficient. But in many instances, maybe they have little kids at home, or maybe they have an elderly parent they are trying to take care of, or maybe they only work very short hours during the week. That is not enough for them to support themselves. And it's hard, right? Especially when you live an abusive relationship, you may be staying at a shelter for a while, trying to get your money together to pay for a security deposit in an apartment, right? Like you may not have credit to be able for the landlord to rent to you. And so there are so many barriers, right, that people are going to be facing. And so it is important for them to know that if they have this affidavit of support, that can be a way for them to enforce it to get some money. So what is it that sponsors have to show, right? So one of the things that the sponsor is doing when he is applying for this immigrant spouse or, other relative is to say, look, I have enough money to support this person at 125% of the poverty guidelines. And so is the government just going to believe him? No, the government is going to want to see what do you have. So there is a list of documents, and we're going to get there in a second, that are going to show that this person has the money to support the immigrant. And if that person, and I do a few cases here at the law school, at the university, where a student is marrying another student, right? So the only thing they have is debt, right? They have nothing. But the US citizen student may have his parents file this affidavit of support on behalf of their spouse, right? Because you won't get that green card unless there is an affidavit of support in place. And so it is important, right, that then the parents usually have to show their taxes, they have to show other documents, right? Because how do you prove it, right? That's also very important when sometimes the sponsor is trying to hide income, saying they don't have enough money to pay the child support or the spousal support. So that affidavit of support can be used to show, right? Like to show the judge that this person in fact had money, because look at all the documents he submitted. So what types of evidence do you guys think? And maybe you can put it in the chat. I definitely told you a few already, right? Like what documents would be enough to show income. And some of the documents may be less in a divorce, but they are definitely not going to be sufficient for the judge, for USCIS to finally say, yes, your affidavit of support is complete. So I'll just go next, otherwise we won't have enough time. So this is the proof that the government is going to require. The tax returns, they want the amount of the last 3 years, only your federal tax return, not the state. They want the last 3 years, but they are only requiring the last tax filing that you had. So the ones I filed this semester with my students, we submitted 2024. In many instances, they don't have income, right? So sometimes we have to get a joint sponsor to help them, but that joint sponsor is only going to be, it's also going to be liable to support the intending immigrant. So you may have a case where maybe the sponsor didn't have money, but his parents did, and so you can have an action against the parents to enforce that affidavit of support. And so it's important to think as well, when you are asking for child support and they are saying they don't have money, you can use the affidavit of support documents that to show the judge that yes, they do in fact have assets, right? Look at all this stuff they submitted, because you want to make sure that your spouse is going to get papers, right? So you submit everything. And then in a divorce action, you're trying to show that you are broke, so you don't have to support your kids or your spouse. And so it can definitely work to your advantage.
And let me just say, judges love this information because oftentimes, especially in a contested divorce case, you're coming in and he's pleading poverty and now he's bragging to the federal government about how much money he has. So in terms of, I've seen judges totally turn around on this evidence. So getting your hands on it and thinking about enforcing is a really good idea anyway, because it really shows that the abuser is a liar and often does.
Self-employed, right? This is hard sometimes because they have to be able to show enough income, but you have all of this information here, right? Like that the government is going to require for them to show that they in fact have enough income to support the intended immigrant at 125% of the poverty guidelines. And we'll give you the amount in a second. We do have this information in the slides. And so it is important, right? Sometimes they own a business, sometimes they have a partnership, right? Like anything like that can show that they have those assets. All of that is going to be important. So a self-employed individual is not precluded from filing the affidavit of support. It's just that the proof is going to be a little bit different as opposed to someone who can get his taxes or a letter from an employer saying this person has been worked here and this is the amount of money he earns. Next, please. So how do you obtain this? And this is important, right? For those of you who are not immigration attorneys, in many instances, when you file a family petition, the U.S. citizen spouse, let's say it's a spouse petition, the U.S. citizen spouse or lawful permanent resident is the petitioner. He is the one who owns the information, and the intending immigrant is the beneficiary. That person is the one who's going to benefit. So that person may not have access to that information. Obviously, if they went to an attorney, the attorney should, it's good practice to give them a copy of the packet, right? Like, here's the packet. This is all the stuff we submitted to the government. But what if the immigrant fled because of abuse and didn't take anything and is not able to come back, is not able to obtain those documents? So, if both of them sign the retainer with the attorney, right, the attorney may say, yes, here's a copy of the documents. But what if they didn't use an attorney, right? Many times people do their own paperwork and they don't keep a copy, right? So it is hard. So you need to be creative with how you're going to get that information. In many instances, doing a Freedom of Information Act request to USCIS to obtain that information is the first step that I usually get, right? And in many instances they how do you say that, they don't give you all the information, right? Like they block some of the information, but they don't block the affidavit of support. They would actually block maybe like a passport. They may block like some other documents as part of the FOIA. The problem is that the FOIA takes a while to get back, right? It's taking, I don't know, between 4 to 8 months. And if you are trying to enforce this document, you don't have the luxury of 8 months. But you can actually get it as part of your discovery in your divorce proceeding, right? Like you can ask for it as part of the discovery. You can ask for it in the interrogatories, right? Like, did you file, right? Like how you can do all of that stuff and have the judge order that he provide you with the affidavit of support. And the judges are going to do it. You are explaining, right? Like you are not trying to harass by asking for those documents. Those documents are important as part of your case in chief, and the judge is going to grant that discovery and possibly, issue sanctions if the person refuses to provide that information. So when does it end? It could actually be forever, right? That obligation to support the spouse or the ex-spouse, it could be forever. Divorce doesn't terminate the ability to enforce the affidavit of support or your obligation to support the immigrant, right? So divorce is not one of the terminating events. Definitely if either of the parties dies, right? Like who are you going to go after, right? Like one is dead, the other one, like what are you going to do? So that's an unfortunate circumstance. You are not able to enforce it. If the sponsored immigrant becomes a US citizen, right? So that sponsored immigrant may be like, you know what, there may be an affidavit of support, but I'd rather be a US citizen that have him support me at 125% of the poverty guidelines. But they should know, right? Like when you become a US citizen, you are not going to be able to continue to enforce it. Let's say she's already receiving money under the affidavit of support. As soon as she becomes a US citizen, that ability to continue to receive the money is going to end. But becoming a US citizen is not a requirement. And so the person doesn't have to become a US citizen if she doesn't want to. If the person leaves the United States permanently and abandons her green card, or maybe she got deported, maybe, who knows, right? Like you don't know what could happen. So then you are no longer able to enforce the affidavit of support. Or if you can be credited with 40 qualifying quarters of work of Social Security, and you accumulate 4 quarters every year. And this is important. And remember, I told you I wanted to come back to the legal separation, because this has been an issue for people who just separate but don't divorce. And then they try to enforce the affidavit of support. But if you are only legally separated, you can continue to get the quarters that you are sharing with your spouse. So if your spouse has already 40 quarters of work and you are trying to enforce that affidavit, but you are only separated, you get his 40 quarters and you get zero support on the affidavit of support. So this is important to think about, right? Like sometimes clients only want to separate. They, maybe they have some cultural or religious reasons for why they don't want to go forward with a divorce. Then, as part of your strategy and explaining to them what you could do with the affidavit of support, one of the things is to tell them, right? Then, if he has these quarters, you are not going to be able to enforce it because you continue to share the quarters with your spouse. The same with children, right? Like children are able to share the quarters of their parents too. And so that's important to make sure that the clients understand. Then, they may say, fine, I don't want to enforce the affidavit. I don't want to get a divorce.
So can I
So
have two questions on this?
go ahead.
One is, when they share the husband's quarters or the parents' quarters, is it for the husband like if I'm in a 4-year marriage, am I only sharing 4 of his years, or is it if he's like how does that work? Like do I have to be in a 5-year marriage to get his 5 quarters if I'm working, or how?
You get all his quarters. If he has 10 years, but you have only been married to him for 2 years, you get all his quarters, all his
Okay.
work history, right, is shared with you.
Okay.
Another thing too is like, let's say you got a divorce, you have that affidavit of support that you're going to enforce against him, but then you go and marry someone else, then you're out of luck because now the judge is going to impute those quarters of your new husband onto you, and
Okay.
you won't be able to recover because you will be at more than 125% of the poverty guidelines, right? So again, strategy. There are people who don't
Right.
understand it or they don't think about it, or sometimes they make decisions without consulting with the lawyer first, right? And if they really want to marry someone else, like who are you to prevent them,
Right.
right?
Right.
Like it's their life. But there are consequences with the affidavit of support.
And can I just say, these 40 quarters issue that we're describing here is exactly the same issue. So if you have a client there are a few states that in order to get, even under the new law, like there are a few states that set a higher bar for Medicaid, for adults, for Medicaid, for SSI, for things like that. Where there's a 40 quarter requirement, it is the same requirement and operates in exactly the same way. So if you have a client that needs SSI, for example, then this 40 quarter issue could be important in that way. So you might lose the affidavit of support, but gain SSI, but he can then divorce her at any time and cut her off from the SSI. So it's like there's that. It cuts both ways, and you should be aware of it.
Another thing that I want to mention, and I don't know if we have this information in the slides, is that you don't have a statute of limitations. I know someone asked, right? Like, are you telling me, someone in the chat said, are you telling me that she can go back into court a year after the divorce and file a motion to show cause with the affidavit? If the affidavit did not come up during the divorce, yes, you can, but you can also do just a civil action, right? Like unless you have other issues that you want to address as part of the divorce, like some other motion for, I don't know, enforcement of, I don't know, forcing a sale of assets or, whatever the case may be. But there is no statute of limitations. So people, and there is a lot of case law where people didn't know they had an affidavit of support or didn't know they could enforce it, and they come back years and years. In the article, we have a case, I think it was like 10 years after the divorce, they came and the judge enforced it. So it is important to know, right, to investigate, does the client have an affidavit of support? And in many instances, right, like as I was saying before, sometimes the spouse, and I had a couple of cases like this, where the spouse had no income, but then he had income, right? Like he had to have a joint sponsor if he didn't have income. But if they say, oh, I don't have any income, so how are you supporting yourself, right? That's one of the things. But it is a little bit complicated when you get a parent of the spouse, because the divorce court doesn't have jurisdiction over the parents, right? That person is not privy to the action, the parent, but you can bring them to court in a small claims or another civil action just to enforce the affidavit of support. So another thing too is that you cannot get rid of the affidavit of support in a premarital agreement or a post, during the marriage agreement. right? Like you cannot terminate that, and you have that. We gave you the case here, the earlier case. Under federal law, neither a divorce judgment nor a premarital agreement may terminate an obligation to support. And remember why this is important, right? The US government wants to make sure that someone is on the hook to support this person, right? That person brought this spouse to the United States. That person committed by signing this contract. So the United States government wants to make sure they have someone they can go after if that person is going to rely on public benefits later on. Okay, so what are the options when the victim sponsors the abuser? So, and this happens, right? Like your client is the U.S. citizen, your client sponsors the spouse, and then the spouse abuses her. So, is there an excuse? Oh, Your Honor, I am a victim of domestic violence, therefore I don't want you to enforce the affidavit of support? No. Remember, the same way contract defenses don't apply, that same way saying that you are a victim of domestic violence and that's why you don't want the judge to enforce the affidavit, it doesn't work unless you meet one of those requirements. And this is when strategy is important, right? Because if you have a client who is going to be subject to a lawsuit for the affidavit of support that she signed for an abuser, then maybe what should happen is that they don't get a divorce but a legal separation, right? Because then the abuser is not going to have access to the affidavit of support because he's going to be sharing the quarters with your client who is the victim, right? So that could be a strategy. Another strategy is if you are in fact representing a US citizen who signed this affidavit of support and she is a victim, file an order of protection. Bring him to court every time he violates an order of protection, right? Like eventually, right? Like maybe the government would start deportation proceedings against this person and that person gets deported. And remember, if the immigrant leaves and doesn't come back to the US, then the obligation to support is going to end. But you are going to have to be, to be able to explain the consequences to the clients, because the same way we're using it to get benefits for our clients who are the victims, we also have to be able, if the abuser has an attorney who's going to say, how did you get here, right? Like the same intake you're doing for your client, then that attorney is going to try to enforce that affidavit against your client, right? So it is important to think about that because it works both ways. There is no exception for someone who is a victim of domestic violence. It's basically you end up having to support your abuser. The same things that apply for our clients' benefits, it could also, work against them if they are the ones who have that affidavit against them. Okay, so what is the difference between alimony and affidavit of support? And just because we don't have time, we're just going to skip the large group discussion. So it is completely separate from the alimony. And as you remember from the beginning of the presentation, in many instances, your clients may not qualify for alimony, but they are going to qualify to enforce that affidavit of support. And so it is important, right? And there is case law. Sometimes the judges, because they don't know what to do with this document, that you're trying to enforce this immigration thing in my divorce action, right? And so it is important that people know that they are separate and distinct. There are judges who just issue a lump sum, and then there are judges who say you have to go to a different court, right? Like, don't come to me, your client doesn't qualify for alimony. And there are attorneys who say, I want alimony because he signed an affidavit of support. And so in many instances, the attorneys themselves don't understand that they are separate and distinct actions when it comes to trying to get money for your client. So how do we calculate it? So this is the fun part, right? So depending on how long the affidavit of support is, right? Like most courts are going to be doing it annually, right? And we have a chart in a couple of slides because the poverty guidelines change almost every year. Sometimes they don't change. Maybe sometimes they change, I don't know, by 500 or $1,000, right? So if you are going to do it per year, then the affidavit of support is going to, the amount is going to change depending on what was required at 125% of the poverty guidelines. So let's go there, I think, so you can look to see what I'm showing you. Okay, so this is the federal poverty guidelines that was effective in March, right? So you can see how many people are in the household. So if it's only husband and wife, then 125% is a little bit over 26,000, right? And so it goes up depending on how many people are in the household, if there are children, if there are other people living in the household, right? And so depending, sometimes the sponsor her and 3 children from a previous marriage, right? And so that's going to be 5 people altogether, right? If they were living together. And so it's going to have, so this is an example of how you would do it. And of course, the government has all of these federal guidelines, right? The 125%. Thank you, Nopur, for putting this together for me. So you are going to be looking at when was that affidavit of support signed, right? What is the enforceability that you're asking the judge to do? Okay, so he never supported me. I just found out that I could have asked for enforcement of my affidavit of support. And, this was 3 years ago. So you go back 3 years and then you find what was the poverty guideline for that year, and that's what the judge is going to do, the calculation per year. That's what they usually do. There are judges who like to do other ways, right? Like if you make it as easy as possible for the judge not to have to do math, that's great, right? Like you can say, Your Honor, this is what I have calculated, but I don't know if opposing counsel has a different alternative, right? Like, but you show the judge that you have thought about it and that you are being very methodical with the way you are doing your calculation.
And this is, I think, the other piece here is to document, like to try to document or reconstruct the point at which she stopped getting any money from him. Sometimes it's when they separated and it ended. But I don't know that they have to separate. I mean, there were places where I don't know how that works, but you have to, part of it is to set the time where this obligation kicks in because he stopped supporting her at a level of 125% of poverty. So if he was supporting her at 10% of poverty, then there was a little bit of money coming in. You might have to calculate it a little bit differently.
Not only that, but also in many instances, the clients have a job. And then, do you want them to quit that job so they can get the affidavit of support? Chances are they are going to tell you no, right? Like they want to be independent and they don't want to depend on that person. But if your client is already maybe even making more money than the abuser, right? And then there is no enforceability issue because you are asking to enforce the affidavit of support to keep your client at 125% of the poverty guidelines. And if she is at that level or above, then there is no, the judge is not going to enforce it, right? Like the idea is to have your client at that level of support that he promised with this contract.
Right. And that's
Oh,
where this transition time, because we know women's incomes take a dive upon divorce, and particularly battered immigrant women. And so you can think of it, the enforcement, if you can say for the last 3 years as they've separated, he's not paying anything and she has filed her VAWA and doesn't work yet, or whatever the story is, this is money that can be super helpful during that gap, like from filing to work authorization and getting a job and getting to a point where she's actually earning more than this.
Yeah, so we are running out of time. And we are going to share the materials, of course, but the next couple of slides we had were different cases to show you how it has worked and how people have been able to enforce them. There are a couple of cases from Michigan so you'll get the whole slide. We have a few slides left, but just in the interest of time. Maybe if anybody has any questions or if Leslie has any announcements, and then we apologize for running out of time with this. If anybody has questions and wants to unmute to address anything specific. This is the slide. So I remember I told you that before 97, the people were filing the affidavits of support, but they were not legally binding contracts. And so these cases are old, right? Like if the marriage is old and your client has one of these affidavits of support, chances are your client may qualify for alimony, right? Because of the length of marriage with the abuser, if in fact there is abuse in the relationship.
Well, I
So,
think last point.
yes, so practice pointers, right? Like definitely if your client has no idea that the affidavit of support exists, it's very exciting to explain it to your client. So she knows that she has hope, right? And that she has the ability to try to enforce the affidavit, right? It's very important at intake, trying to figure out if your client may have one, like who signed it, right? Like, does she have a copy? Sometimes they come to you with a bag full of papers and they have no idea. So I usually tell them, let's just dump all the papers on my desk and let's figure out what you have. We're just doing a case like that right now because it is important, right? And make sure that you take advantage of the discovery tools that you have in the family proceedings to be able to get this information if your client doesn't have it.
That's great. Well, thank you so much, Veronica, and thank you for everybody for attending. Know that you can contact NewApp and we'll connect you with Veronica or we'll assist you if you have one of these cases. But really these can be a lifeline for battered immigrants. We will be getting you hopefully shortly a model brief on this that could be helpful, particularly in domestic violence cases. And I want to thank Veronica for sharing your wealth of expertise on this issue. She is really one of the experts in the nation on this.
Thank you. Thank you. Have a good day, everyone.